Thanks very much for the invitation. My name's Mary Fox. I'm a lawyer based at the University of Liverpool, and I've in this field I've worked mainly on the bodily integrity in the context of genital cutting, mostly of boys. So it's been really instructive for me to think about the wide range of examples that Clare has spoken to. So I'm not going to use slides, Brian, and my response to Clare is probably quite random in ways it's picking up particular issues that were very thought-provoking for me. It's been a great pleasure to read your book, Clare, and just to say that I'm broadly sympathetic to Clare's approach. Like her, I would argue that law should, as a starting point, think that non-intervention is better in the case of children for most of these procedures. Um, I'm going to only aim to speak for about 10 minutes or so because I'm really interested to hear what the other responses are. But just to say that lawyers absolutely love hard cases, but we do tend to focus in on particular hard cases. So I think it's really interesting to think about how law might respond. Clare said our intuitions might be very different across these range of cases. And I think certainly if you look at legal responses across the range of issues that Clare has raised in her talk, it's very clear that they are fairly ad hoc, perhaps, and have developed over time. And approaches across different jurisdictions are interesting. So I think lawyers become obsessed with jurisdiction. And I think it might be interesting for us today in fleshing out how we all understand bodily integrity from different disciplinary perspectives, to think also about how jurisdiction and culturally where we are based might influence that. I think Clare mentioned the Tattooing of Minors Act, which might be one example of legal response where law attempts to regulate access to procedures and to prohibit the performance of procedures on children. FGM might be another context where law takes a stronger approach and essentially tries to ban that intervention. But of course, that raises all kinds of questions about what is a form of mutilation, and cosmetic interventions in that kind of context are tolerated. And then, of course, it doesn't attempt, except through common law, to regulate the performance of procedures on boys, and that makes it largely a matter of parental choice. And I think, again, something that Clare and I share is questioning really the limitations of choice in all of these contexts that we're looking at. So I think that might be a really interesting question for us to pick up today. The other thing that struck me, I suppose, across the range of examples that were provided, some of which have been tested in law and some of which haven't, is that the idea of the child is perhaps something we could speak about over the course of today. Because the interventions that are proposed interventions that Clare has discussed do take place on children at very different stages of development. And I wonder if there is a difference. So the right to an open future can apply clearly for all children, but I do wonder if it becomes easier, and this is also relevant when we think about hypothetical consent. When we're talking about very young babies, for instance, the case of neonatal circumcision, then perhaps that's quite different from something like the administration of puberty blockers, although I think it's really interesting in that context how those interventions tend to be proposed earlier and earlier, and that's something that obviously has been a cause of concern recently. And then the other thing about the interventions, which I suppose speaks to the reversibility point, which I really haven't thought about a lot in my work, perhaps because lawyers don't think so much about reversibility, but it's whether, surgery as usually an irreversible intervention is different from something like the administration of hormones. And I think the question of harm, so when I was thinking about reversibility, I was thinking lawyers perhaps tend to think more in terms of harm. And that's another very nebulous principle, but thinking about how non-intervention relates to ideas about harm and who gets to determine harm and how we can appreciate harm in the context of other persons or other beings. So thinking through reversibility more, I think, is very instructive for our conversations today. And then I wanted to focus in a little bit on the best interest principle, which Clare turned to after looking at reversibility. And clearly, this is a well-established principle, not only in ethics, but it's very much enshrined in law. It's increasingly enshrined, I think, in statute law, in the fields of children and healthcare. And I wonder if there is a place where law has a contribution to make, because I think Clare's criticism of the best interest principle as being something which simply shifts disagreements about intervention to a conversation around what best interest might mean and how it plays out in these very different contexts, is helpful. And it's very much chimes for me with some of the early criticisms that health or medical lawyers made. Ian Kennedy has fundamentally criticised the principle, and some of his criticisms were later taken up by John Harrington, who essentially argued that it can be quite dangerous. Because given that our judges aren't necessarily very representative, he says if judges essentially make common sense decisions in the context of determining best interests, then they are likely to play out in really problematic ways. However, I think more recently, perhaps judges have made really concerted attempts to flesh out what best interests might mean and to really try and articulate how it plays out in cases involving children or those who are otherwise unable to consent. And to an extent, this plays out in statute in the Children Act and perhaps more clearly in the Mental Capacity Act. And certainly when Michael Thompson and I have tried to argue about best interest principles in the case of circumcision, we tried to build on those initiatives to argue, and I think this does chime with Clare's arguments, that perhaps one way of thinking about best interests is to think, well, what are the core principles that can give content to best interest assessments and perhaps constrain the ability of judges to make fairly random interventions depending on perhaps whether, they think circumcision, for instance, is an acceptable social norm. So perhaps using bodily integrity in a way that is a starting point, and that then does suggest non-intervention should be how we begin to think about best interests in the context of decision making for children, might be helpful. And I suppose just another observation there, that if we are thinking about somehow fleshing out or giving content to these principles like harm, like best interests, like bodily integrity itself, maybe one of the points at which I have some reservations, Clare, about how you framed bodily integrity is in the discussion around it being a boundary, which of course in many ways it is. But law has struggled with boundaries, and I think very often lawyers think about them in terms of territory almost. It's defending territory. And I do wonder how that plays out in the context of conjoined bodies. So not only the conjoined twins example, where the norm might be to separate, but also in the pregnancy context. And I think there's an interesting question there about, does bodily integrity apply to a single body and then it struggles with these conjoined bodies? I think it does perhaps suggest that our body is our property, and I wonder how those kinds of property arguments play out in our context. So can bodily integrity be more than defending your body as property? And I just wonder if that's something that we could maybe focus on. I'd be really interested in other people's thoughts on that. So I'm going to throw the floor open in a moment. The final point I wanted to make, which is where Clare's paper ends, is on the idea then about other principles that come into play. And the final line of her written paper talks about insisting on the moral privilege of the unmodified body, and that this is to insist on the humanity, the dignity and respect owed to people who inhabit all kinds of bodies, which means all people. And I think that clearly does throw open, well, what do we mean by all people? And one of the reasons it's really nice for me to join this conversation today is that I haven't really been thinking about bodily integrity or indeed children for a while, and my recent focus has been on animals. But I did begin to think about, in the animal context, what might bodily integrity mean? Um, and is it a value which applies actually beyond people, or do we need to expand our notion of people? So I think there is, which I realize this might be quite a particular text, so I won't necessarily go into all the details about why I think bodily integrity actually might be a value that applies beyond the human, in a way that, for instance, I don't think dignity really can. But I do think bodily integrity is so important because we might need to think about how we rule out, I think, easy cases of intervention on animals' bodies. And I'm thinking about those dogs that are being imported with cropped ears, things that are outlawed, like ear cropping and tail docking, under our Animal Welfare Act. But interestingly, coming back to the question of jurisdiction, are not outlawed, for instance, in the United States, where you can declaw your cat if that might be a reason for you to keep the cat, for instance, or cut the vocal cords of your dog if your dog's barking and causing an annoyance. And those, I think, are fairly easy cases for us to rule out ethically. But I think there are also harder cases, and I've been thinking quite a lot with one of my PhD students about neutering of animals and how we tend to think that is in the best interests of animals. But actually, the medical evidence is becoming more and more contested about that, especially in the case of male dogs. But also thinking about animals did make me think, and some of the resistance of animal owners to interfering with their rights to modify their animal bodies as they would see it, did make me also think about the way that we do conceptualize children, to come back to that point. And I do think that in addressing the question of personhood, one of the problems here is that law really does see both children and animals perhaps as being property still. I'm not convinced that we fully regard, I mean, others like Catherine McKinnon and other commentators have argued we don't necessarily fully regard women as being persons yet. But I think there are some resonances with children and animals, and particularly, I think, in the Ashley case, which I mentioned to Clare as a case I'm really obsessed with. But it does seem to me that one of the ways in which it's difficult for law to intervene with parental choice, or indeed the choice of animal owners, is that very often the parents are motivated by what they think is really a loving act or a caring act for their children or their animals. And in the Ashley case, I think the interventions to make her body manageable very much treated her as though she is a pet. And it's not necessarily that we don't love pets, but we don't accord them the privileges that we would accord, or rights we would accord, to persons. So Clare, I loved your paper. I think it's given us a fantastic starting point for our discussions today, and I think it's thrown up some really challenging philosophical, legal and other questions. So thank you very much.